Yes, Ms Jones.
May it please your lordships, I appear on behalf of the appellant local authority in this matter. The court kindly having excused the social worker's attendance given our application yesterday. The respondents appear as follows. The mother is represented by my learned friend Mr Sanders, father represented by my learned friends leading counsel Miss Lee, King's Counsel and junior counsel Miss Oakes, and then the children via their children's guardian who is watching remotely, represented by my learned friend Mr Barnes, who is assisted by his instructing solicitor Miss Lamb.
Thank you.
Lords, this is an appeal against the decision of Recorder Hennessy, dating back to the 11th of April of this year, her judgment effectively following a finding of fact hearing.
I'm sorry to interrupt.
Apologies.
No. Can I just mention, I know everyone will know this, that we are being live streamed, and so it's very important that we don't mention any names. It can very easily happen. Judges sometimes do it inadvertently, but if we can just bear that in mind, please.
Of course, my lord. I've indicated the decision and the date of that decision that is the subject of this appeal, my lord. The case relates to a number of injuries you'll see outlined in the revised skeleton argument from the local authority at page 25 of the bundle, paragraphs 11 to 16. It's electronic bundle. I see you have the bundles in front of you.
Yes, thank you.
You'll see there collectively 8 injuries that the local authority seek findings in relation to. 7 of those, 6 bites and 1 ear injury, and then the further injury to the ear, which was based on the parents' evidence given before the court, that was added to the schedule and obviously submitted to the court for consideration. Effectively, the local authority documentation, if I can just take you through that to ensure you have everything before you. You obviously have the notice dated the 30th of April of this year at page 1 to 2 of the bundle. My lords, also the grounds of appeal dated the 18th of April of this year and associated skeleton argument with the same date, running through from page 13 to 22. We have the revised skeleton argument for the local authority dated the 7th of June of this year at page 23 to 33, and the amended threshold document, and apologies for that not being included previously, at page 39 to 42, and finally the statement of reasons dated the 23rd of June of this year at page 97 to 99, my lords.
Can I just be absolutely clear? I think I have followed the position, but the document which begins at page 39.
Yes, my lord.
I noticed the index has a slightly different heading given to it, but this is headed Schedule of Findings sought by the local authority in support of threshold criteria.
My lord, I think the explanation is the index hasn't been updated to reflect the nature of the document switch.
No,
so
I just wanted to make sure this is what you just referred to as the amended document, is that right?
That's correct, the original.
Fine, and that's what was before the recorder as being the findings of fact which the local authority invited the recorder to make, is that right?
My lord, yeah. Absolutely, yes.
And as I understand it, at least as part of your grounds of appeal, I think it's ground C as lettered, a particular complaint is made by you about what we see at pages 41 and 42, that, is this right, that those final 13 to 17 paragraphs that you say the recorder failed adequately to make findings in respect of those matters?
My lord,
right.
Yes.
I understand.
And they relate to failings alleged by the local authority, conversely, that follow on from other findings potentially in the case, my lord.
Thank you. Right, you're just taking us through the relevant documents.
Of course, I simply wanted to check you had all the documents before you and certainly a clear picture of the local authority's input in this appeal. The grounds of appeal, which you've already referred to, my lord, essentially 2A to 2E of that document being at page 13 to 14.
Yes.
Specific in nature in the sense that 2A refers to the submission and the ground put forward that the judge fell into error. She failed to reference the schedule of findings sought as a document and also to outline them as sought by the local authority. 2B, I don't know whether you want me to go through them. They are before you. I'm happy to take you.
I think we can take them as read.
I'm very grateful for that indication, my lord. Essentially, if I can expand somewhat on the document before you.
You appreciate the reasons why you're all here, Miss Jones, because notwithstanding the fact that this appeal, I assume it's still the case, the appeal is unopposed, we took the view that we wished to hear it fully argued. I hope that's all clear.
Absolutely, my lord, yes.
How we've communicated with you. Could I just ask you to summarise the position of the parties, if you can? So you're saying that we should allow the appeal on all grounds and remit the matter for a full rehearing before another judge?
The position of the parties collectively is inviting this court to allow the appeal, to remit it back to the court for case management by the designated family judge in Liverpool.
Judge Parker.
Yes, my lord. And for onward timetabling as he sees fit. There have been some discussions about what that would look like, my lord, as far as obviously rehearing, whether it can be narrowed. And I noted in, very helpfully, from my perspective, the Guardian's responses that you've had sight of, talking about whether or not position statements would be helpful to see whether the parties could narrow certainly some of the issues that might need rehearing. For example, if there's an acceptance that they are bites, we can then move on and narrow and focus on the next hearing if that happens and you allow the appeal and remit. So there certainly have been discussions, my lord, about that, and I can assist you further in that vein if you wish.
Well, certainly, speaking of myself, I shall want to know in due course, but not out of turn, please, what each of the advocates says should happen next. If it's agreed, fine. If there are nuances and slightly different positions, then we'd like to hear that. But I don't want to take up time now.
No, of course, my lord. Although the local authority do appreciate, and I think it's an appropriate juncture for me to say this, if I may, we do appreciate that our grounds, we do pursue all of those at this appeal. However, we also acknowledge that other parties, I think particularly the parents, have advanced other potential areas additionally that may come under our umbrella of a ground but are specific in nature, and we're able to respond to that.
But you're the only appellant, aren't you?
Absolutely.
There's been no notice of appeal by any other party.
No, and I did notice that, but nevertheless I'm in a position to respond if the court is assisted in any way by that response.
And another factor, without overcomplicating the matters, and I hope not putting you off your stride, it is possible that this court may allow the appeal on one or more than one of your grounds, but not all of them.
Absolutely, my lord, and that is the reality of this hearing, although the local authority would say that this is a blanket, comprehensive failing as far as analysis and application of law.
Before, if I may, just one further question before you get going. It would help me to know, and I think all of us to know, exactly what the current position is. It's very concerning, Ms. Jones, that these proceedings have been going on for over 2 years on what is not a particularly complicated case. At least it doesn't. Can you shed any light as to why it's taken so long?
My lord, certainly in general terms, delay has been factored into the proceedings due to explanations that the medical experts needed to explore and tests and the like that needed to take place in respect of the child. And that unfortunately did have that impact on this case. And essentially all of us are keen, and I hope no one minds me saying this, everyone is keen, and no doubt the court are keen, for this to progress expeditiously. But the local authority would say it does need a clear and solid factual matrix to do that. and this isn't what we have.
And the children have been living with their grandfather, have they?
They have,
For 2 years now.
They have, my lord.
And is that that is under an interim care order, is it?
Yes, my lord. And it is a settled placement, although we appreciate it is a family placement, but nevertheless a resolution to this case sooner rather than later is in the child's best interest.
Of course. But again, just thinking of the sort of overall ambit of the proceedings in the future, is there any prospect of these children being placed outside the family?
As it stands from my understanding, no.
Thank you. Thank you. Those are my questions at this stage. Sorry to
No
distract
apologies
you.
required, my lord. If I can deal, my lords, with the grounds in a summary approach and group some of those that maybe correlate together in my approach. When looking at the schedule of findings as a document and the structure or lack of structure in which the judgment was proceeded with in my submission on behalf of the local authority, the lack of reference to that as a document, as a starting, middle and end point, caused in my submission some difficulties. Essentially, the only reference is the highlight to the local authority's what's called a pragmatic view from the local authority, which I would support, in respect of the calf injuries, given the evidence we had heard, and obviously trying to focus the court's minds. The judgment didn't have that structure in my submission, or the cap-in-hand progressive analysis that one would have if one had gone through that in that way. And in the local authority's position is that that has unfortunately led to aspects of the schedule not being properly considered. Shining examples of that being the failings, paragraph 13 onwards of that document, and also notably in the local authority's submission, the injury to the left ear, which is, on everyone's look at the medical evidence and what was heard by the court, a very serious injury and something that clearly needed to be thought of with more care and attention and analysis. The local authority would say that therefore there is a clear lack of solid ground for a factual matrix to be able to then go on to forward risk assess these parents or parent to be able to properly and justly resolve this case with a just outcome.
Do you say the judge's analysis leading to the conclusion that the injury was inflicted is deficient?
In relation to, I'll be clear, in relation to the bites, you'll have seen
Yes, that's
from...
what I'm sorry, that's what I mean. The bite marks.
Yes, in relation to that, the skeleton argument was aimed at, and I'm sorry if it wasn't clear, that we accept that analysis of infliction. It was in line with the medical evidence. Unfortunately, the same approach was not applied to the ear injury in our submission, simply left, unfortunately, as an afterthought, and the focus, unfortunately, was just on the bites and left the ear injury with very little, if any, analysis.
There's about a page of a judgment on that, isn't there?
Yes, and to be fair, my lord, there was a lot of evidence from Dr. Cunningham about that, not only in examination in chief, but in cross-examination. And I will expand upon that, if I may, at this juncture. Clear evidence from him, it was an unusual, very serious, inflicted injury. Clear evidence that it would have resulted in a significant pain response. It would have been out of the ordinary and a noteworthy event for these parents or whoever was caring for the child at the time. He effectively had ruled out the explanations advanced over and over by the parents, particularly in respect of the sibling. And then during evidence, he also extrapolated potential examples of mechanisms when they were put to him, and he gave very detailed evidence in support of different mechanisms. And I can expand upon that if it assists the court, but essentially the point being made by this local authority is that that is absent from that analysis. And that is the failing that, particularly to do with the ear injury, is of great concern to this local authority. and against the background of a lack of analysis, we would say across the board, of digging deeper and engaging with the evidence, my lords.
Can you help me with a very basic question? We have at present a finding from the recorder that both parents are within a pool of potential people. And I understand the criticism of the reasoning that leads to that, but how does that finding prevent risk assessments in the future? Because surely people who, this is to my untutored eye, people who conduct risk assessments in the future will have not only all the evidence available to them that was available to the recorder, but also any updated evidence that might be relevant. And so at the moment I don't understand how the future progress of looking after these children is prejudiced by the criticisms that you make of the reasoning.
My lord, essentially the outcome is based on, we would say, inconsistent analysis of the evidence, and therefore that amount of inconsistency and not engaging with the wider evidence to reach firm conclusions about the credibility and propensity of both parents, regardless of whether they stay in the pool at the end of that exercise or not, is meaningful information that the local authority or whoever assesses these parents as far as risk would then be able to engage in meaningfully with the parents to then properly risk assess. Whereas because of the lack of proper and holistic analysis, we are left with, yes, an outcome, but the basis of that is not solid ground, we would say.
Can we break that down a bit, if you don't mind?
Of course.
And I'm sorry, I don't want to take things out of turn, because you may be coming back to these,
Not
but it
at
may
all.
just help you. Certainly if you understand what's causing me a little concern.
Absolutely.
But first of all, as you all know, this is the Court of Appeal and is not here to conduct a rehearing. Our function is a review, and particularly when it comes to findings of fact, it's very much a matter for the trial judge. And it's well established, there's lots and lots of authority which says, for example, the mere fact that they don't mention a particular piece of evidence doesn't mean that they haven't taken it into account. In the field that I tend to specialise in, we often say things like judges are not there to sit an examination, and we're not marking an examination. Anyone can be hypercritical after the event. So I know you understand all of that. So what we're going to find of real assistance, if I may say so, is if each of the parties before us today can focus on particular parts of the judgment and explain to us why they are deficient. And that leads me on to my second point, which is you've mentioned in particular the ear injury. It may be that that's a useful starting point in analysing the judgment. That's at page 62, at paragraphs 146 to 150. I don't know if it helps, but it may help you if you draw our attention to those 5 paragraphs and explain to us why they are deficient, and deficient to the extent that an appellate court should allow an appeal rather than say, well, we might have expressed ourselves differently.
My lord, absolutely. If I focus first of all on the ear injury, as you've indicated, and looking at paragraph 146 and 147 particularly, the local authority's position is that the court engaged in dealing with the injury at first instance, that it's mentioned. It's then focused on discounting the sibling in paragraph 147. And the local authority position is thereafter, apart from dealing with that issue of the sibling, there is very little, if anything, engaging about the extensive evidence heard. It's essentially 2 or 3 more paragraphs and a reference to Dr. Cunningham in 148 that effectively is not touched upon. And then the outcome in our submission would tend to suggest very strongly that there wasn't an engagement with that evidence, because we don't have any meaningful path of how it was caused when we have clear evidence of certain mechanisms where it could have been caused that way.
What was the local authority's case as to how it had been caused at the conclusion of the evidence?
Dr. Cunningham, just to give some context, my lord, if I may, concluded in his evidence with potential examples of mechanisms. Effectively, he opined inflicted by crush between a surface or a heavy blow directly to that specific area. In the evidence, he then considered options being put by the parties, and they were explored, and he gave opinion in this way. Firstly, where there was no skull bruising, and particularly none behind the ear, a forceful impact by a hard object, and that would mean that the outer bruising had resolved. That was one scenario. So it was inflicted that way, but that it has resolved by the time, obviously, medics saw it, or it was pinching. And he gave evidence that it was very unusual, not impossible, and it would take significant force, but notably that it would account for the parents' evidence that on the 27th or thereabout of April of 23, there had been a similar injury to that very same place on that ear, and then the further injury on the 10th of May. And he also made the point, and it's a peculiar place, that the exact spot twice was not normal, effectively, and that fed into him considering and giving evidence on mechanism.
What was, forgive me for interrupting you, what was then the local authority's case to the judge on the ear injury at the conclusion of the evidence?
The closing submissions on the local authority's case was essentially that given we were advancing two ear injuries, one based on what was seen at the medical and one which was alluded to by the parents in evidence, that we had two within 2 weeks, and that effectively that brought us to submit that it was a pinch. A forceful, significant pinch to that same place, which would explain the lack of injury anywhere else in that location, in line with Dr. Cunneth's evidence. When we submitted it with strong evidence.
But that would lead to, if the recorder accepted that case, that would lead to a conclusion that it was inflicted by one of the parents.
Yes.
Well, you've got that, haven't you?
My lord, I think the local authority's position is to say it's unexplained doesn't assist the local authority in any risk assessment of that injury. Effectively an afterthought.
I should have clarified. Was the local authority making a submission to the judge as to the perpetrator of the pinch?
No, the local authority's position was that it was unclear given the situation at home, the caring responsibilities, but we put forward, and we continue to do so, that it's one of them and the other would have known about it.
One and have I got this again, and forgive me, what was the local, I know it's not helpful to switch between injuries, but helpful to know this at this point. What was the local authority's case at the end of the day about the bite marks? Were you making a positive submission that it was one of the parents at the end of the evidence?
No, it was the same position given the nature and extent of the evidence for the odontologists and Dr. Cunningham on this. The local authority took the view that both stay in the pool because there wasn't clear evidence, we would say, one way or the other to point to one parent over the other. But again, one did it potentially. I suppose two aren't ruled out by the medics, and the other one would have known about it given the visibility of such injuries.
Can I just come back to the ear? If you read 150 in isolation, it might be said, well, the judge hasn't said that it was inflicted by one of the parents, but she's not able to say which one. But when you read the judgment as a whole, is that still the case, or can one infer that that is what the recorder is holding?
I think the resounding takeaway by this local authority of that injury in the context of that judgment is that the left ear was left to one side and the focus was the bites, and leaves us uncertain of the grounds.
You may be right, but I just wonder if what the recorder was saying in the final sentence, in light of the remaining findings in this case, I need to say probably no more about that she's really saying, I don't know, when read fairly and as a whole, is the judgment really saying that the position in relation to the ear injury is the same as in relation to the bites, that both parents are in the pool of potential perpetrators, but that I'm not able to say which one. Is that a fair reading?
My lord, having looked at it again, it is open to that interpretation. However, having been in the room and heard it, and in the context of how it was said, the local authority took it away that it was not a blanket approach, that it was one of the parents, and it was a clear way forward with the ear injury. And we don't have in any of those paragraphs reference, for example, to the findings sought by the local authority that it's a second injury as well. So 2 injuries in total. It's very much this injury. To be fair, they were not mirror injuries completely. The 27th of April one is alleged to have been bruising with some swelling, but nothing as significant as the May injury, which had the haematoma. And therefore we would have expected, if that had been the rationale for paragraph 150, for that to at least have been mentioned, to give us that clear indication that that was the thought of the judge.
Thank you.
I don't know whether, in relation to the ear injury, I know I've spent a lot of time on that, and we have touched upon the approach to perpetrators. One thing I probably should address, out of a sake of completeness, my lords, is essentially the position of the local authority as to the bites, in case you do need some assistance on that. Both odontologists did stress the need for caution throughout their evidence. Both alluded to limitations of the photography, even the ones taken in the child protection medical. And also, in excluding the sibling, they were cautious about further exclusion of either parent, effectively. And also, it was in our submission with caveats, tentative potential exclusion of mother with caveats, and important ones. Distortion was mentioned, angle of biter, position of person being bitten, and movement, generally of both, and also capillaries were mentioned in the evidence. There are a number of factors which have made the local authority more cautious about approaching it as in we can exclude one parent, and to actually approach it on both parents should stay in the pool as an outcome. But how we get there and how that information helps us to then risk assess is crucial in our submission. I wonder whether I could address you on some parts of the evidence that we say are examples of the failure to analyse, particularly the parents' evidence, credibility and propensity. I know I have cited some of those in the skeleton arguments. If I can extrapolate that somewhat. The local authority would say that as a consequence of the approach of the judge, that there is that lack of analysis, and importantly a lack of challenge by the judge to looking at other pieces of information and evidence and how that sits with or does not sit with the evidence from either parent or both parents. A particularly prominent example of this is considering how each parent's evidence sits against each other, and against the wider background. In the pool of perpetrator determination, we would say the outcome, as I've alluded to, is not really grounded in evidence to assist with assessment. No real evaluation of that evidence and factoring in, obviously, their credibility importantly. It seemed to be a focus on opportunity only. So style over substance, effectively, of one thing has dominated without anything else.
But are there specific passages that you criticise? Because, again, if I may respectfully say so, we have to be careful. As I've stressed, we are the Court of Appeal. A, we don't have all of the evidence. B, we don't have live evidence. So it's often been said that we can't island hop in the evidence. The trial judge saw and heard all of the evidence. And I'm not saying that means that you can't challenge findings of fact, but the submission may be one of different kinds. If the submission is that the recorder erred in law, we need to be taken to her self-directions on law to have that explained to us. If that's not the submission, but the submission is that on the evidence that was before her, it was not reasonably open to her to make a particular finding, again, we need to be shown that. Third possibility, I suppose, is that the recorder was required to make a finding about a particular matter and failed to do so. Again, we need to be shown where she addresses something or fails to address it in the judgment. I hope that's helpful. It's intended to be.
Absolutely, my lord, and I'm very grateful. If I can, first of all, deal with some examples then of the inconsistencies in evidence and therefore how that feeds into a lack of analysis. Paragraph 66 of the judgment, which is page 53, my lords.
Yes, thank you.
The judge in that paragraph deals with the overall impression of the mother's evidence. Essentially, one sentence is mother doing the best she could with the remit of what she recalled. And that the judge has said, I don't necessarily form any impression that she was trying to lie or make things up, but that is a different issue. Just summarising and certainly quoting some elements of that paragraph, my lord.
That's 66.
It is 66,
And that's
yes.
After 19 earlier paragraphs about the mother's evidence.
Yes, yes. And I take that on board, but that really gives us a summary of where the judge was then at, having considered all the elements of the mother's evidence. Not that she hasn't considered the evidence she has given, but whether she has dug deeper, and we would say she scratched the surface. And when you look at other comments made by the judge, which I can direct you to, it shows a lack of consistency in approach and analysis. So if you contrast paragraph 66 with paragraphs 54 and 55, my lords, at page 51, and these are examples which I hope you find helpful. Paragraph 55 is dealing with mother's evidence when challenged in cross-examination about failings. So that aspect, essentially, of the findings sought, that she says in the evidence for the first time, so not in witness statements, not in police interview, for example, that she had called the health visitor after she thinks the second bite. So not the February one, the March one, or thereabouts. The judge engages in that she says it's not in her written witness statements, didn't give a satisfactory answer why that was, is what the judge goes on to say. And essentially leaves it with, she says it did seem to be quite an important thing to address, that she allowed these to happen, these injuries to happen, without real inquiry or real worry. That, in my submission to this court, demonstrates, on the one hand, this is someone who has been assessed by the judge to not be lying or holding things back, But then conversely, we have a prime example in evidence which undermines the mother in my submission as to her truthfulness and her veracity, and it's not taken further. Effectively, the next step is not taken by this judge, because it would, I would suggest, be important to look at these examples and to see whether actually the first impression is the wrong impression. Digging deeper would delve into whether this is someone who is essentially lying to the court over and over again and trying to explain away without substance why she didn't reach out, or if she did, it's someone else's fault that it hasn't happened.
Now, Ms. Jones, what you're putting to us is a critique of the judgment. But your position is that the judge's findings, you don't challenge the judge's finding that the bite marks were inflicted, and the judge's finding that neither parent could be excluded from the pool of perpetrators.
Correct, my lord.
So, the moment, for my part, I'm slightly puzzled as to the local authorities' approach. One might have expected your position to be not that you are appealing against the decision, but rather these are the sort of submissions one would expect responding to an appeal, or perhaps saying, on a respondent's notice to an appeal, the finding should be upheld on other grounds.
My lord, I can understand that questioning in that way, and at first blush I can understand it, but when in this situation of the destination may be where one wants to be, but the way we've got there is not a meaningful, evidential based and grounded path, which then makes the next step impossible or very difficult to do in a very just and fair way to these parents.
If at the beginning of paragraph 66, the recorder had added the words, taking all these aspects into account, my impression of her evidence is da 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 da.
But my lord, with the greatest respect, I then question whether that could actually have been the outcome, having considered the examples, and there are other examples in her evidence where one may question really her credibility. So the local
she does say overall might be said to be as one word for the words the Lord has suggested.
So, but I mean, are you challenging the finding that she was doing the best she could within the remit of what she recalled?
Yes, my lord. Given the aspects of her evidence, yes. Effectively, we were dealing with, and just taking her in isolation, a mother who had not noticed or done much about these injuries. We had some text messages with the maternal grandmother, but very slow off the mark to do anything. Very quick to blame sibling, we would say, and also even in the face of evidence from the medical experts that the sibling could be quite properly evidentially ruled out. Essentially, she didn't have enough teeth in her head to be able to do those bites in the way they presented, that we then have in her evidence her saying it was a disappointment that that was the case. And that was explored, and I appreciate you don't have the evidence before you, but there were a number of examples that in our submission would lead to questioning her credibility before the court and not being completely truthful about what happened.
So the position then is you challenge the finding in 66, about the assessment of her evidence, but you don't challenge the overall finding that the mother's in the pool of perpetrators.
Correct, my lord, and that may seem disingenuous. It's not meant to be. I'm
not suggesting it's disingenuous, but I'm picking up on what my Lord Justice Singh has been saying, which is that it creates not entirely straightforward questions for a court of appeal.
And I appreciate that on behalf of the local authority. But we would say it's a wider issue. There's examples in her evidence that should have fed into and been properly analysed, rather than scratching the surface, we would say, of the evidence and the competing pieces of evidence. For example, we have medical evidence which says that any parent or carer who was looking after this child would have known there was something wrong. He would have experienced significant pain month after month after month after month. Every injury would have had that same outcome. To have blissful ignorance or lack of knowledge about that, we would say, is a difficulty. And that global picture, we would say, hasn't fed into the analysis that had taken place. We heard evidence, for example, the injuries, the number of them, the timing of them, lack of explanation I've just touched upon, my lord, lack of reporting injuries. And if you recall, some injuries, the ear injury in May, only came about to go to the GP and then the medical, the child protection medical, because the grandfather noted it and suggested that mother should do something about it.
So what you're saying is that there were factors which pointed towards the mother being the perpetrator, and there were factors which pointed towards the father being the perpetrator. The judge in the judgment identifies some of those factors, but not others.
I would say, and I would take it a little further, yes, my lord, but taking it one step further, I would suggest to the court that it then undermines the assessment of, overall, I think she's tried her best to give evidence in a straightforward way, when effectively the heart of her evidence is in difficulties because of all these other pieces of evidence that undermine her, and also the lack of consideration, and it's an important one in my submission, the family circumstances and dynamics of their relationship, which we heard an awful lot about, that effectively created a boiling pot of issues in that small flat, and the acceptance by both parents in evidence that this had escalated to arguments, and on occasion heated arguments. Again, how that practical side of things would then feed into credibility of what really happened in that flat to cause these injuries.
Why does the failure of the judge to deal with all of these points undermine the assessment process that's going to follow? Insofar as they're unresolved issues, can't they be explored in assessment?
My lord, it could be explored in assessment, resolution model assessment, in all likelihood.
Well, for example, the relationship issues that you've alluded to.
Yes.
That would obviously be a matter for assessment, wouldn't it?
Of course, my lord.
And the fact that the judge hasn't made any findings about that doesn't jeopardise the reliability of any assessment.
No, it doesn't, in a very straightforward approach to an assessment, I agree. Although there are some other factors that the assessment would be more meaningful if we had clear evidence. If these two parents are not lying to the court, then where does that leave that assessment? Number one. Number two, I would suggest, rather curious reference at paragraph 67, page 53, my lords, about the kinship assessment, with a reference from the maternal grandfather saying that these are parents that don't appreciate risk, leaves a rather curious situation for assessment when you're talking about inflicted injuries and the type of inflicted injuries, my lord.
I mean, it might be said, Miss Jones, that where the judge has conflicting evidence from the witness box about these matters, it might be said it's better to leave the exploration of those issues, for example, relationship issues, to the assessment process, as opposed to coming to too rigid a conclusion on them on the basis of the admittedly artificial process of giving evidence.
My lord, yes, and I would accept that there are elements of a risk assessment that would delve deeper, obviously, and explore that with each parent. But the local authority would say that the rudimentaries that one would normally, the building blocks, so to speak, of those conversations starting, of whether the court have an assessment of these people are telling us the truth, but they're both in the pool of perpetrators and one of them inflicted or both have inflicted some or all of the injuries, and therefore the potential, and this is the failings, to protect, brings a package for that assessor to then properly look at. At the moment, we don't have that in my submission, and that causes difficulties. Not the outcome, as in the findings themselves, but how, and I've said this a few times and apologies for it, but the path that is followed that informs that assessor in basic terms to then step off the path and explore with each parent. We don't have that solid ground, we would say, and that is what is lacking. That will cause difficulties and will potentially cause a lack of fairness in assessment for these parents.
Is that unfairness that could not be cured by a future judicial hearing?
My Lord, the local authority would say that this needs a rehearing, whether fully or partially, depending on what could be narrowed by the parties, but we would say can only be resolved by an appeal allowed, remit, rehear.
Yes. On that specific point, can I return to a question that my Lord Justice Baker mentioned earlier this morning, which is, I stress we have no views whatsoever. We're just exploring various possible outcomes of this appeal. But suppose, for the sake of argument, we were not persuaded that all of your grounds of appeal are made good, but that we did think that the judgment is deficient, as you assert in C, or the third ground, or ground C, in relation to failure to protect. And it was the findings at paragraphs 13 to 17 in your document that you particularly say that the judge failed to address. Just suppose, for the sake of argument, that that was the outcome. What in practical terms, on your submission, would happen next?
Then on that, we would say narrower issue, that there would need to be some element of rehearing in this case. It would be more limited.
Right.
Would not involve the medical, obviously, but some scrutiny, and at least we would have a response to those elements of the schedule of findings sought, whereas we don't have anything in that regard.
There's a difficulty with that. Isn't there a potential difficulty? Because presumably you would not be, say, rehearing by the same recorder. And if you don't have a rehearing by the same recorder, you run the risk, and you have a partial remitting. You have the risk that the new judge takes a different view of the parents to the Recorder Hennessy. And that would create havoc.
Wouldn't it have to be, if on that basis, if we dismissed, this is a hypothetical, remember, Ms. Jones, we're thinking through all the options, it's not straightforward. If we were to dismiss the appeal on grounds 1, 2, etc., but uphold your appeal on failure to protect, on the basis the recorder just hadn't covered it, which is what your case really is.
Indeed.
We'll come on to the merits of that in a minute, but if we decided that, could we not then remit the matter back to the recorder to address that particular issue?
My Lord, I think in those circumstances, that is certainly an option that could happen. She is then best placed, given the way the appeal had progressed, to then deal with that and remedy that, assessing her view of the failings, if any, and findings she would make. So yes, I appreciate what the court is raising and understand that that would flow from that and could flow from that.
The premise would be that the premise of that outcome would be we weren't accepting your criticisms of the judgment, apart from her failure to deal with this particular discrete, separate issue. You know what I mean? Thank you.
Indeed, my Lord.
Now, I don't want to curtail your submissions at all, but there have been quite a few questions for you, but I just want to make sure that you cover the topics that you need to cover. But at some point, as my lord has mentioned, we would certainly benefit from your submissions on the merits of ground C or the third ground.
My lord, yes. Although I would observe, as far as the local authority position is concerned, that we would say that failing does extend to the left ear, and I've heard
Yes.
what
Yes.
your lordships have said about that, but I just wanted to make it plain that
Yes.
that is what is being advanced.
No, we understand that.
As far as 2C is concerned, the local authority would say that it is far from helpful and in fact difficult to envisage a full assessment and a risk assessment to be able to take place. And the failing was a comprehensive one because effectively it was not touched upon at all and should have properly fed into the next steps of her judgment, and it abruptly stopped. And in those circumstances, we would say that those matters should have been ventilated and findings should have been determined one way or another on those.
Yes. It's actually findings 15, 16 and 17, or paragraphs 15 to 17 in your draft threshold document, isn't it?
Yes, apologies, my lord.
Narrowing it down a bit, because 13 and 14 really are all tied in with the
That is fair.
non-finding as to perpetrator.
Absolutely, my lord, yes.
So it's 15, 16 and 17.
And we would say that ties in with the lack of analysis of the background and the circumstances in the home and the relationship that we would normally have expected would have been explored when looking at failings as well, and the dynamics of that relationship that would have been prudent to cover and should have been gone through in that document and adequately met with either a finding or no finding. And therefore the absence of that, it is a failing by this judge, and therefore we would say should be allowed in this appeal.
Because we're not going to hear any opposition to your appeal, can I just test that by putting forward something which occurs to me as might be put forward if we were going to hear? See my
course,
point?
my lord.
So I'm not expressing a view, I'm just trying to test it.
Yes.
Might it be said that given her finding as to perpetrator, non-finding as to perpetrator, which accorded with the local authority's position, she wasn't in a position to make any finding about failure to protect?
My lord, I would submit to the court that it's not as clear-cut as that, because it was open and should have been explored by this judge as to one or other has caused some or all of the injuries, and whether another parent in that scenario of that environment, and we heard lots of evidence on that environment, should have known and should have acted. And those were elements of evidence that were firm ground for the judge to say that effectively the pool finding stands, but in the alternative of there would be failings by one parent if they were not the perpetrator. And that would fairly and squarely have put it in the judgment and a proper basis for assessment.
Now, given that your case is the recorder did not do that, does that mean that for the future, you and any future judge considering the case is precluded from addressing that question? Or what's the problem in practical terms? What difficulty does this cause for the future?
Because effectively we would have the very open pool of an assessment of looking at both parents in an equal way and not reflecting that there were clearly findings in the alternative that would help with their general situation, and that would help the assessment, we would say.
Well, I can see if your complaint is that it would have been helpful. I can understand that, but I'm not sure that that's a reason for allowing an appeal. where the question, because what I'm interested in knowing in particular is in practical terms what's going to happen next. If you said to me, what this means is, the judge's failure means that we can't, for example, make an assessment about what one of the parents should have known. If they weren't the perpetrator, what should they have known? And therefore we can't make an assessment of it. And that a future judge who has to make any relevant order about the children will be precluded. But I'm not hearing that. I may be wrong. I'm not a family law specialist, as you know. But what I'd like to know is whether it would be possible for those things still to be addressed in the future, or whether you're saying this judge's failure has precluded those things being addressed.
The local authority would say that as the end result of these failings, yes. That effectively she hasn't referenced the schedule of findings in the way she should and used it as a working document. We don't have findings that we have asked for, one way or the other a determination. That has not happened, particularly in relation to those paragraphs. We then have the next step is that it's uncharted territory for an assessor to then have to try and fill in the gaps when it could have very easily and straightforwardly have been dealt with one way or the other by this judge when approaching that document.
I'm pursuing the same line as I did before, but in the light of my Lord's questions just now. Really, what you're saying is there's one sentence missing. In the light of my previous findings, one or other parent failed to protect. Full stop. And again, not as a family specialist, as you will also know, that seems to me to be the inevitable consequence of the judgment that we've got at the moment. So when my Lord says, would people be precluded? My response is reaction is slightly different, which is it's all there. It's all there, and you can go ahead on that basis, even without the finding from the judge. I know you'll come back at me and say that, but the reasoning isn't good enough and all that sort of thing. But that's why I've suggested that it's a single sentence.
My Lord, being blunt about it, one sentence will be better than no sentence in that regard. And I do take...
Very frank of you.
Very frank. I hope that's...
it buys you at least 10 seconds.
It does. It's great advocacy.
My Lord, I take on board the point. Yes, one sentence could have been sufficient, but essentially we have a judge who hasn't engaged with the document at all. This is clear from particularly those paragraphs, and that is a failing in itself. But then the next step would be that even with that one sentence being added, we're now expecting someone to infer that when it's not been specifically dealt with as it should have been. And it's not trying to be picky, it's here to ensure that findings sought are dealt with properly one way or the other and determinations made. And it would be helpful to have that based on evidence to assist the next step, which is the risk assessment. So I take on board the one sentence, and it has been a recurring point that is quite properly made, but that's the answer of the local authority globally.
There's been case law on this, isn't there? Lady Justice King talked about it, danger of it being a bolt-on, didn't she?
Yes.
Now, failure to protect is a label, isn't it? What we have in this case, the question for an assessor is, does the mother or father, the parents together, by the way, still or not?
No, separated.
No, separated. Does the mother and or father have the capacity to protect the child? Now, with the absence of the label that they have failed to protect, you're right, that's not there. But we do know a number of things about the history, that the child sustained injuries on a number of occasions, that they took photographs of the injuries, that they didn't seek medical advice initially, that they then did seek for them, and the mother sought medical advice after the grandfather raised it. So, and those are just the ones I can remember. There are lots more little pieces of the factual history which would inform an assessment of the capacity to protect the child. What does a finding, a sort of headline finding of the sort you were seeking, materially add to the assessment process?
My Lord, against a backdrop of the judgment that mother was doing the best she could, I'm using her as the example, that mother was doing the best she could in evidence based on her recall, and then we feed into the mention of the kinship assessment of these parents may not appreciate risk, then you're looking at those factual points that you've quite properly pointed out, and there are many, many more. One would not have a clear path and would be filling in the gaps that this judge should have in my submission, have nailed down for the assessors to then act upon quite properly. There could be criticism made in my submission of an assessor who then infers, assumes, reads between lines when it could have easily have been dealt with in the judgment, because we asked for those findings and did not get, one way or the other, an answer in writing in that judgment, or when obviously she delivered it, that would help us. Conversely, if we approach it in the way you've just suggested, then one would question the need for even putting them on such a document in certain circumstances. We would say that it should be clear all options of what failings and what findings are made, and a judge should meet those one way or the other, and it hasn't happened in this case.
I mean, failure to protect is not a specific threshold issue, is it? It's
No.
it's based on a series of factual findings, which are all there. They're not really, some of them aren't at all contested. So the letter of instruction to the assessor could set out, if necessary, the factual matters upon which the assessor would be asked to carry out the assessment of capacities to protect.
Yes, although without any backdrop, save for that she gave very credible evidence. And how does that feed into all of those points? And an assessor would, in my submission, struggle because it would conflict. On the one hand, she's being truthful and is helping the court and doesn't know how these injuries happened, and yet is still in the pool of perpetrators, and then is being assessed in that way, and then no alternative findings have been made. It's a curious situation, we would say, for this local authority to then try and build on a very fair and proper and appropriate and comprehensive assessment of mother or father or both.
Right, that's very helpful. As I say, I don't want to curtail your submissions at all, and you must, of course, deal with all the topics that you think are important, but where are we going next?
My lord, the only point, and looking at the points I had to raise with you, to hopefully assist, was simply to make similar points in respect of father. You have seen those in the skeleton argument with the references. Effectively, again, the general approach to both parents was a superficial overview without the substance and not taking the next step, and that can be applied, as I say, to the father, the rabbit in headlights, but then not for her to determine or to guess, and she won't go there, effectively was her answer in short. Full short, and again supports the submission that this judge did not do what she should have done as far as these parents and their evidence and credibility. Other than that, my lord, I have addressed everything I wish to raise above and beyond what is in the skeleton arguments, and unless I can assist you any further.
That's very helpful. May I check if there are any other questions? No.
No.
Thank you very much.
Very helpful.
Now, is it Miss Sanders?
My Lords, I appear on behalf of the mother in this case. My Lords will have seen the skeleton argument that I have submitted to the court. The mother's position has been throughout this case, so including the finding of fact hearing, that there were a series of significant inflicted non-accidental injuries caused, and that includes 2 ear injuries as well as multiple bite injuries, and that there's no real debate about the fact that these were inflicted injuries. That is a line of argument that I put to the paediatrician, and he agreed with in the lower court. The mother's case is also that it can be said, as a matter of probability, that one person inflicted those injuries. And in my skeleton argument, I've drawn the court's attention to the judge's conflation, really, of two issues. One, whether it can be said that they're all inflicted by one perpetrator. And at various points, there are references to her not being able to identify the perpetrator. And those two different points are used interchangeably in the judgment. The mother's position is very clear. It can be said that there is one perpetrator, and that these are very serious inflicted injuries. Serious in the sense they're inflicted, and they would have caused a degree of pain, a high degree of pain to this child. Now, it is important, if that's right, when one considers risk going forward, that there is a material difference between the court identifying that perpetrator and not identifying the perpetrator. An assessing social worker going forward who doesn't know who did it, to put it bluntly, may form their own view, but it's difficult to sustain a view like that if the court hasn't been able to. And in my submission, that's the first problem, really, with the court's failure to identify the perpetrator in the case.
Local authority hasn't invited any court to identify a perpetrator.
No.
And you haven't appealed.
No, indeed. The approach that I've taken on behalf of the mother is this, that the submissions that the local authority makes, and they are detailed in many, is that this is ultimately a deeply flawed judgment. And that when one adds to it, as I seek to, the points made in my skeleton argument about the judge's failure to consider all the expert evidence properly, renders the finding that this is a pool case, that this is an O&N finding essentially, wrong or unsafe. The my lords will have seen the skeleton argument. I asked the learned judge to consider three areas of the evidence. One was a paragraph in the minutes of the experts' meeting, which was really started to clarify the experts' thinking on the identification of the perpetrator in terms of the bite marks. Well, bite mark, actually, it was the 18th of April was the only solid image that they were able to look at and say, that's a probability. We can say it's a bite mark. What happened was that the experts then, of course, had asked for casts of the teeth of the parents, and Dr. Kubel then filed a subsequent report to that experts meeting, which I have quoted in my skeleton argument. And I make the point that for all the discussion, these experts came to the view of my submission that the balance of probability was that it was the father who had, it was the father's dentition that gave rise to the marks that were seen in the picture on the, it's at 184 in the bundle, the clear picture of a bite mark on the baby's face with the numbers. I don't know, my lords have seen that. But there is another aspect that I also submit. In fact, the learned judge didn't quote parts of Dr. K's, I should be calling him Dr. K, Dr. Kubel's evidence. And I've quoted those in my skeleton argument. But the learned judge didn't actually quote anything from Mr. P, Mr. Parsons. And he gave detailed evidence about the track marks that appear on that photograph, and that he was looking for sharp edges to teeth that would have caused those marks. And there's no real discussion of that. The word sharpness doesn't appear in the judgment, and there's no real discussion of that part of the evidence. So my submission is that when one adds these points to the points that are made by the local authority, that essentially there are a number of points raised by the judge that don't come to any conclusion as such. They are left hanging. There are loose ends. That long list in the local authority skeleton of points really they're points where the learned judge has decided something was said or done, but then hasn't gone on to say what she thinks about it. And that leaves a problem for anybody in my submission assessing risk in this case going forward. Could I address what should happen next? Because my lords, I think, began with that question.
You said you asked the judge in particular you said the last 2 or 3 minutes have been about what you asked the judge to find, and I thought you said 3 things in particular.
My lord, yes.
And I got down, the first one was the identification of the perpetrator from the bite mark on the 18th of April. And the second one I've got down, and I'm not sure whether I'm following your structure.
Sorry, my lord.
Evidence of P and looking for sharp edges.
Yes.
Am I misnoting your submission?
If I refer, my lord, to the skeleton argument, which appears at P87, which is electronic page 90.
Yep.
And at B there, hope it's...
Okay, you've got them there. Yep.
I set out the 3 things that the court was invited to consider. I set out those 3 matters. I'm developing, I suppose, A, in the sense that I've also added that the judge failed to consider the oral evidence of Mr. Parsons. So she didn't refer to the minutes, which I've quoted there, and she didn't discuss his oral evidence in her judgment.
Thank you.
And it's both those matters together, really, that I submit are conspicuously absent from the judgment when one is trying to decide who's responsible for those bite marks. Dr. Kubel, I've developed the point further down, but it's a quote from Dr. Kubel's report of the 14th of March that is seen at B, little b. And after all the debate, I draw the court's attention to what I've put in bold there. I would conclude that it is unlikely that her teeth would leave the pattern scene. So what I'm saying really, or submitting on the mother's behalf, is that the judge, in discounting this medical evidence, has left certain matters out from her discussion in her judgment that ought to have been considered, that I asked her to consider them, and she doesn't appear to have considered them, and that renders the analysis flawed. And the reason I say, I would submit this comes under ground 2B, effectively. It's the complaint by the local authority that the analysis throughout is flawed, and I seek to add these to the argument.
The passage in B, forgive me for interrupting you, in bold, I will conclude that it's unlikely that her teeth would leave the pattern scene.
Yes.
Appears in the judgment at paragraph 121.
Yes, further down in the skeleton, I consider these, and at large D, I say in respect of this, I'm not saying that she didn't quote that.
Yes.
I'm saying that she didn't give sufficient weight
Yes.
to it.
But I have to say that as a judge of this court, it always strikes me as something that I need to pay particular attention to. When a submission is made, the judge gave insufficient weight to a particular piece of evidence, because that submission may be well-founded, but I'm not sure that it's really our role to start saying that more weight or less weight should have been given to a particular part of the evidence. As I've already mentioned earlier this morning, we haven't seen and heard all of the evidence, as the trial judge did. So where does that submission really take this court?
Well, I understand the point my Lord raises. I seek to add it to the other points that are made about the way the judge has analysed or not analysed the evidence. It's a cumulative effect in this regard.
It seems to me, and I may be wrong, in which case please tell me, there is a difference between the emphasis or the weight that you and Ms. Jones are adopting. So she is criticising the analysis because the absence of analysis itself hinders subsequent assessment. You go further. You say the absence of analysis is so serious that it vitiates the findings.
Yes. My lord, yes.
In
In relation to the bites, yes.
in relation to the bite.
Yes.
Well, and then would you go further, which would seem a possible logical step? If you upset the bites, you've got to have you really upset the whole apple cart.
Apple cart. My lord, yes, and that's what I submit. And I submit that leads me to consideration of what the future hearings could look like. I don't know if my lords want me to go there.
Certainly, I would be assisted by this. If we were to dismiss this appeal, and it's the local authority's appeal, not your appeal, but if we were to dismiss the appeal, on your submission, what would happen next in practical terms?
Well, if the appeal was allowed, the case was remitted to the family court in Liverpool. There's two. I have known this court to contact the family court directly and find out availability of judges for X number of days hearings. I've been in a case from this court that went back directly. The usual course is to remit it to the designated family judge in Liverpool, who would hear the case within a week or so.
That's if the appeal's allowed. So you would invite us, I think, as the local authority to remit it to the DFJ with a view to case managing it, with a view to getting on your submission there would have to be a full rehearing of everything. Would you? What would happen if we thought there was merit in some of the grounds of appeal but not in all of them? Would you accept that then there would have to be a partial rehearing?
Part of it depends upon whether it goes back to the same recorder or not.
Right.
If it went to a different judge or recorder, then they would be left in a rather difficult position of being told that the findings by another judge in relation to the perpetration had been made. And they may, when they read the papers and read the transcript, if that's the way we proceed, of the expert evidence, might have concern about that. And they would be left with the findings, as it were, set in stone in relation to the O&N finding in relation to the parents, but having to go to to address the failing to protect issues. And that would, I would submit, that would put a court in potentially an invidious position.
Right.
If it goes back to the same recorder with effectively a finding of this court that the findings made on the perpetration are upheld, and the direction to look at the failing to protect, perhaps I ought to address what I say about the failing to protect.
Yes.
There are all manner of failures to protect, but as I understand it in this case, the local authority are interested in what the state of knowledge was of both these parents. So it goes beyond being slow off the mark to seek medical attention. There is a proposition being made or submission that will be made that, for instance, if the father is the perpetrator, that mother knew very early on and did nothing. And it almost gets to the point of an argument that they're colluding. Now, those are very serious failing to protect, but this judge has not touched any of that in her judgment. And that's the sort of discussion that a subsequent assessor needs to be able to think about, because they have to consider whether it's possible to rehabilitate children to parents who, if a finding was made that it was not the mother, it was the father that inflicted these injuries in the way that the extreme way that I've described in the beginning of my address, but that there is very little at the moment, very little to be said about her ability to protect from him, then that's a level of failing to protect that at the moment there's none of that in the judgment. There's no factual matrix that gives rise to that sort of. I'm not arguing for it. It's not against my client, but I think that's what the local authorities concern is that there isn't a proper exploration in the judgment of the state of knowledge and action or inaction on the part of these parents.
How could the judge make again, I'm putting the point back to you because you're not being opposed, how could the judge reach a concrete finding as to the precise nature of any failure to protect when she was unable to make a finding as to the perpetrator? And there's a spectrum, as you said, active collusion, turning a blind eye, negligence, too busy. Or there were others on that spectrum. How could the judge make a finding as to where either parent, the non-perpetrator, fell on that spectrum if she wasn't making a clear finding as to perpetrator? Wouldn't that be speculation rather than anything?
It would be, but it would be speculation in a way. Often there's an A and B scenario that is explored. So the court would go down the line of...
Remind me what that is.
Oh, sorry. Well, for instance, social workers are often asked to do assessments on the basis of whether a finding is made or not made. And the court would have to consider, I suppose, I'm not suggesting this is ideal, but the court would have to consider what can be said if each of the parties was the perpetrator and therefore the other one was their actions, what their actions and what they've said about those actions tell the court in relation to fail to protect. That's what I mean by the two scenarios. Yeah. But it's difficult, and it's a lot better if there's an if it can be done, that there's a perpetrator identified.
I understand.
That's the core of the risk going forward is the uncertain perpetrator.
That's very helpful and clear. I understand that. But can I just return to a question I asked about 5 minutes ago? Just help me with this, if you would. Suppose, for the sake of argument, we dismiss the appeal completely. What would help me to know is what your submission is about what would happen next in practical terms. So I think you've just touched on that it may make life difficult, but it wouldn't make it impossible, is what I'm hearing.
What would have to happen is that the case, if the case was completely, the appeal was completely dismissed, then it would go back to Recorder Hennessy. There would be directions for assessment, including risk assessment of these parents. There may be a resolutions kind of assessment, which involves considering what support around the family is available and whether it is possible that children can be protected, making use of what's known and that kind of family support. Those assessments would be done, I dare say they would take more than a month. And then there would be a further, this was always a finding of fact hearing, so there would have to be the welfare stage of the hearing would have to be listed.
Your client's, I mean, you skirted around it, but is your client's position that these injuries were inflicted by the father?
Yes.
And that is something which would be explored. Your client's reaction and comments about that would be explored could be explored in the assessment.
Yes. Yes.
Yeah, and would be if the appeal is dismissed.
Yes.
But one consequence, and I think you acknowledge this, of that very clear approach may be that it'll then be said that the mother should have done more.
Almost certainly.
Yeah. As you've acknowledged, that could be contrary to your client's interests.
Yes. To
have such a clear finding.
It is apparent on the chronology of events that she took a photograph of the first bruise was on the exact date, it was February. The second bruise she took a photo was March. The third bruise she took a photo was in April, that's the one that we have. Yeah. And then subsequent to that, she took the child to the doctors, and that was after her father had asked her to, yes. Effectively. Now, on any view, there's a point somewhere there where there's a fail to protect in
Well-
terms of failure to seek medical, and that's conceded, and that was conceded at the in the hearing.
But could it not be said, Mr. Sanders, you're putting this very, if I say so, very fairly, could it not be said that these sort of exquisite, subtle issues are best explored in assessment rather than in the artificial environment of the courtroom, as I put it earlier?
Yes.
We know that the facts are all there. We just don't have a label of failure to protect.
I respectfully agree, my lord, but it's not a subtle, nuanced issue as to who the perpetrator was. That's the point, the big point that will raise difficulties for assessors in my submission. It's not the rest of it, which can, of course, over many sessions, no doubt, with the social worker be teased out, and I accept that. So my main point really is that there could and ought to have been a finding of perpetration in this case.
Well, Mr. Sanders, that I understand, but the law, as I understand it, I've looked at the authorities in the bundle, contemplates that is where a trial judge ends up. That although they have to go through the process we all know about, according to the authorities, they may end up, as this judge did, of being only able to identify a pool of potential perpetrators, but not able to identify, even in a case where there is known to be a single perpetrator. Now, if that's a course that was open to the trial judge as a matter of law, and she heard all of the evidence and read all of the evidence, then and you haven't appealed,
no.
Then on what basis could this court upset her decision on not finding in terms that it was the father?
Well, I think I'm going to go back to my original point,
Yes.
which is that the submission is that the judgment overall is so flawed
Yes, I understand.
that this is an unsafe, I'm not sure that's the right way of putting it, but the finding should be upset for that reason.
No.
That's where I think I started, but that's my submission.
Not on the procedural point just raised by my lord, you would say, or would you say, that the local authority having raised the appeal, other parties all having agreed or supported it, we shouldn't be too sniffy about the absence of additional documents setting out people's position and things like that?
I don't know how to answer that, my lord.
I
think you're going to agree with what I've just suggested.
Carefully with my advice.
Well,
No, I understand exactly how you put your case, and if I may say so, like my lord, I think you've done it very fairly.
I suppose one question that my lords very kindly have not asked is this: would this appeal have been made purely on the points that I take in the skeleton argument, as opposed to with regard to the rest of it? And all I can say is we have not appealed, have we?
Yeah.
And it's the cumulative effect of the flaws in the judgment plus my points within my submission render this.
That's very helpful. Thank you. I don't want to curtail your submissions at all, but is there anything else you wish to add?
I think I've reached an
May I
natural
check
end, my
if
lord.
any other questions?
Thank you very much.
Thank you very much indeed. Now, Steve.
My lord, thank you. My lord, I'm conscious that the message came from the court to be prepared to argue the opposite to what we had submitted. And
I don't think I quite put it like that.
forgive me, my lord. And listening to the exchanges that have taken place and the issues that appear to be of most concern to the court, namely findings, I think 12 or 13 onwards. In the
failure to protect was
Yes.
an issue.
Yes, one of the issues. Can I just highlight, because it certainly wasn't completely clear to me, that those findings were added at the conclusion of the evidence. They weren't part of the original schedule that the judge was considering at the outset of the hearing. So they were added at the conclusion. My understanding is that the exchanges that have taken place about failure to protect in the spectrum, certainly it wasn't pursued during the hearing on the basis of collusion or the parents being challenged that one or other must have known about it because of, for example, the size of the flat, etc. So it may be, as my lord has pointed out, that this judge was left in a position not being able to identify a perpetrator and then not being able to assign what knowledge the non-perpetrator had, so couldn't make the failure to protect. And the failing in the judgment is that that's not addressed one way or the other.
Was the original threshold document, by which I mean, or I suppose it may have gone through various iterations in the way it normally often does, was the original, or the one before the judge at the start of the hearing, the same as the final one, save that paragraphs, whatever it is, 14, 15 or 13 to 17 were added? It would actually, for my part, help me to see what the judge had in front of, recorder had in front of her on day one.
Well, also, if I may say so, what was being asked of her as she was hearing the evidence?
Yeah.
Yes.
In other words, what was put in cross-examination to each of the parents? Because that may have coloured how she then frames her judgment.
Yes, which is why
Yes.
I raise it, because in some respects it might be an unfair criticism of the judge
It would be.
had it not been at the forefront of her mind when she started hearing the evidence. On looking at, I've just been passed a hard copy of the original threshold, which is dated the 13th of March, so I think that was probably the week before.
Effectively day one.
Yes.
Yeah.
And it stops at paragraph 11 of the one that you will have before you.
On page 39.
I think that's right.
My lord, I wonder whether I could interject, and I don't mean to be, I mean to be helpful in doing so. The background is this, that the original document did have some element of failing to protect alluded to. That then evolved prior to the finding of fact hearing, with other counsel having had a conference and a view taken to take it out. When we started the finding of fact and during the currency of that hearing, it was plain in cross-examination across the board that those elements were being teased out and challenged with the parents, and it was inevitable that they were going back in. And that was change of counsel, namely me, and the evidence, how it evolved. And that's how the final document was provided, but on the very clear understanding from the judge throughout the process, from what was being asked, and asked by the judge as well, of the parents in particular, and the medical professionals about failing to protect, particularly the paediatrician, that it was definitely in play and would be potentially back on the document, and was. So I hope that helps with the evolution, but the court was very much appraised of it.
I'm very familiar with how these documents evolve. I'm not so long on the tooth I can't remember that.
Yes.
This is typical of what happens, and I recognise what you said about change of counsel, etc. But you have structured, I'm addressing you now, you have structured your appeal on the basis of the judge failed to follow the schedule of findings.
Yes.
And frankly, it can't have been easy for her, a recorder, dealing with this evolving case. I make that observation. So for my part, it would be helpful for me to see, I think my colleagues would like to see, the document she had in front of her at the start of the hearing. I think it would also help me to see, us to see your, which would have been your, I imagine, opening note, or whatever you call it, position statement,
Indeed.
case summary, so we can see what she was preparing for.
Of course.
That's all I want to say.
Yes, I agree.
I hope that assists, though,
Yes, it
answers
does.
some questions.
Yes, indeed.
So, my lord, just doing a quick scan of the two
You
documents.
said it stopped at 11, did you?
It stops at 11, and so the document that we have then dated the 20th of March, which my learned friend Miss Jones prepared, I suspect, at the end of the evidence, then adds paragraph 12 through to 17. So I'm assuming I'll be corrected if I'm wrong. That
Okay.
supplemented the submissions that were made.
Again, drawing on my rather now too distant experience of these things, what would have happened is that this wasn't on paper, but it emerged in the way it was developed in cross-examination, as Miss Jones has described. But it wasn't something to which the parents had formally pleaded, if I can use that word, in the way that would have happened. There would have been, I assume there was a threshold document with responses.
Yes.
Yes, there was. There's usually a threshold document with a box with a schedule. Parents' case. Not. Okay.
Yes. But I don't believe from memory when I looked at the original bundle that the response to threshold was the 20th of March. It was the original.
Yeah, it would have been.
Yeah.
Right. So.
Would there have been closing skeletons?
Yeah, there would have been a closing written submissions.
I mean, if
They were oral submissions,
Oral
I
submissions,
understand it.
Right.
And the judgment was given, I think, 3 weeks after the hearing concluded, but extempore from notes.
Yes.
was there a transcript of submissions?
No.
No.
May I just return to one point that's been raised with you, which is the parents' response documents. I don't think we have those in the appeal bundle. I think for the sake of completeness, we should see those as part of the package of documents that are going to be sent through to us.
I agree. Can I make another point? Which is that it may be that there was more, it's complicated, more than one early threshold document, which maybe there was a threshold document which did include an element of failure to protect. Sorry, Miss Jones' eyebrows.
That's my impression.
So it may have, there was a sort of moving target here, to which, so I think, I think we'd like to, for my part, I'd like to see all the documents at all stages, so we've got the clear picture of how it evolved, how it ebbed and flowed.
Yeah, I agree.
Yes.
We need to see what my lord has called that iterative process.
Yes. And I'm sure those documents can all be gathered together. It struck me that my understanding is that the evidence was not pursued with the parents on the basis of collusion. And so, as my lord pointed out, it may well be that the judge, and she does go through in her judgment why she doesn't feel the evidence, looking at the medical evidence and the wider evidence, why she can identify a sole perpetrator.
Yeah.
And she does deal with that. And deals with it in respect of each parent. And so, on behalf of the father, we don't appeal on separate grounds. We supported the appeal because of the lack of clarity and the lack of analysis. But of course, it is open to the court under the Emery-Reinbold test for the judgment to be sent back to the recorder to ask her to consider filling the gaps, as it were, or addressing the failure to protect issue. In relation to the ear, and obviously I am putting the contrary arguments, but in addressing the ear issue, whilst it's right that from the submissions that have been presented before the court, there was a lot of evidence about the ear, and that it was considered, certainly by the paediatrician, to be a significant injury that would have required significant force. what the recorder does say at paragraph 150 is, but I think in the light of the remaining findings in this case, I need to say probably no more about that.
Yeah.
And certainly the significant injuries are the bite marks. And she does come to the conclusion, that the April one is a bite mark. She comes to the conclusion that therefore the other marks that were seen and photographs taken by the mother and then at the hospital were more likely than not bite marks. So she finds all of those as inflicted injuries. But for the reasons she sets out, leaves both parents in the pool. And that's what led her not to strain to try and speculate how the ear injury may have happened, because it may well be that in her mind, the most significant injuries were the multiple bite marks that she has decided were inflicted.
And of which she had photographs.
Yes.
In some instances.
Yes.
And a clear and extensive medical evidence.
Yes.
So what you're saying is, and it's not your case, this is very helpful, Miss Lee. What you're saying is, it would be open to us to conclude that the judge's treatment of the ear injury was not wrong, given the totality of the evidence, in particular,
Yes.
her detailed analysis and findings in respect of the bite mark.
Yes, and there's no criticism of her detailed analysis of the bite marks. She goes through the evidence very carefully, the medical evidence.
Mr. Sanders.
I know Mr. Sanders does, but certainly the local authority says there can be no criticism of her analysis in that regard. And whilst Mr. Sanders criticises the weight the judge attached to various parts of that evidence, she did address that submission at paragraph 135 and says respectfully, I disagree, and then sets out why she disagrees. So certainly this court can be satisfied that there was a clear and coherent analysis of that medical evidence and the wider evidence that led her to come to the conclusion that both parents should remain in the pool. And certainly on reading her judgment, she balances on the one hand that the doctors effectively say that they would be cautious about excluding either parent, but maybe more so cautious about the father. And the judge reflects on that and says, but equally on the other hand, the evidence presented before me is that the father had little or no opportunity. And when he did have any care of the children during the relevant time period, the mother was always present. And she reflects in her judgment that the mother's clear evidence to her was that she never heard a cry that would have been caused by an injury being inflicted as set out by the experts, and nor did she see anything untoward. And faced with that wider evidence, she was then entitled to come to the conclusion that the only appropriate finding would be a pool finding. In relation to the failure to protect aspect, that position may become clearer once the court has had the opportunity to see the direction of travel of the schedule of findings and the responses by the parents. But certainly it is open to the court to ask the recorder to look at that discrete issue again if once those documents have been considered, it does appear that it should have been addressed and was not. The alternative is that it was an unfair criticism of the judge to say that she did not address it if it only appeared at the close of submissions, at the close of evidence and during submissions. And certainly, whilst I wasn't trial counsel, I understand that the failure to protect was more explored on the basis that if, for example, the father was the perpetrator, then the mother must have known about it because she was in the flat at all times when he had the care of the children in that relevant period. I think there's reference to one occasion where he cared for the children alone, but that was outside of the time frame for these injuries. And when looking at that evidence, she wasn't persuaded that she could identify one parent as a perpetrator. So then it might logically follow that she then doesn't go on to make a failure to protect finding because she might, in her mind, have been thinking that would just be a bolt-on, which she was not allowed to do.
Does she quote Lady Justice King?
I think she does at the beginning, when she directs herself on the law.
No, she quotes Lady Justice King on Don't Strain.
Yeah.
Oh, yes.
Yeah,
No, she doesn't. I don't think she does do it.
I cannot assist, but one of my learned friends may be able to, as to whether the recorder was directed to Lady Justice King's decision in relation to failure to protect LW, I think, because she appears in her judgment to be reflecting on the guidance that she has been given by the advocates at the hearing.
That case is noted at paragraph 35, but there isn't a quotation from.
Is that the bolt-on case?
The LW case
That's
is
the bolt-on.
referred
Yes. Thank you. Yes.
Just so I was using shorthand there in response to Mr. Barnes. What I mean is that is the authority, is it, in which Lady Justice King refers to the difficulties with failure to protect findings being used as a bolt-on. That passage. Okay, we've got it
In the authorities manual.
Thank you.
Yeah. So, in terms of directing herself on the pool of perpetrators, I don't think there can be any criticism of that. She sets out at paragraph 143 the test that she has to guide herself through, which she's already set out at paragraph 41. And in essence, my lords, we would also highlight the fact, the delay that my lord has raised, 2 years that these proceedings have been ongoing, and the delay that will be incurred if there is to be a retrial.
Have you got any submission to make or observation to make as to why this relatively simple case has taken over 2 years?
My understanding is that there were delays in obtaining medical records. There were then substantial delays because of blood tests that were recommended by one of the experts that then had to be repeated, I think.
Okay.
And that created a significant delay. My understanding is also that the case really only crystallised in terms of excluding the sibling as a possible biter, if I can put it that way, very shortly before the case began. So right up until shortly before the case began, the sibling was still regarded as a possible biter.
I may say this, even allowing for those complications, 2 years does seem a lot.
It does.
Very worrying time for these little children. It's just...
They have effectively been out of their parents' care longer than they have ever been in it. And certainly this court has questioned about the difficulties of an assessment being undertaken where there are concerns about the lack of clarity within the judgment. In relation to that aspect, one approach would be that the findings that the recorder made should be set out in writing. That can be done, whilst she doesn't specifically reference to the schedule. It's clear that she has made the significant findings about the bias. That can be set out.
Would it be possible, do you think, Miss Lee, drawing your experience in these cases, for a findings document to be set out which went some way beyond the local authorities' proposed findings to record specific findings that she made on some of the details?
Yes, and that would certainly assist any assessor. My understanding is also that, and resolution assessments have been raised.
I think you'll have to explain, remind me and explain to my colleagues what a resolution assessment is.
It requires somebody who is specifically trained in these type of assessments, but it is an assessor who can assess parents when they are denying, for example, that they have caused an injury to a child. And we often see within the family justice system, families reunited where the court has made findings of an inflicted injury and the parents are in denial. But there are other factors that allow the family to be rehabilitated. And the key one is their recognition of risk and ability to protect in the future, and or alongside a supportive family network. And my understanding of both sides of these children's family, maternal and paternal, is that they are very supportive. And I think my lord will see that obviously it was the maternal grandfather who insisted the mother take the child for medical advice and has been caring for the two children since 2020.
And facilitating the contact.
Yes. As has the paternal grandmother for the father facilitating his contact. So there is a close and supportive network around these children, which would assist in that type of an assessment being undertaken. And with a clearly drafted schedule of the findings that the judge did in fact make, that would help any assessor to look at the key issues. And as my lord has already pointed out, matters such as relationships and risk would form part of that assessment in any event, even if the judge hasn't referred to them within the judgment.
Is there an extended family on the scene on both sides?
Yes.
There's paternal grandparents as well?
As I understand it, it's the paternal grandmother who's supervising.
Paternal?
Yes, so the father's mother is supervising
Okay.
his contact. So I think there is supportive family network on both sides.
And the resolutions approach, as I recall, correct me if I'm wrong, is as you say, it's where there's been a there is a denial of but a finding. And it's particularly suitable for cases of course, this was a serious injury in one sense, but it wasn't the most serious injury in terms of injuries to children. So this is the sort of case where that approach might fit.
Yes. Yeah. I would go so far as to say it is definitely one of those cases where this type of assessment would be suitable because there is the supportive family network around on both sides of the family. That, of course, would allow this case to progress to welfare, and it is another important aspect in the context of this family that the parents separated in July 2024, and there is no evidence that they are back together. And so it's, as I understand it, the mother who is putting herself forward to care for the children, and the father seeks contact. He works full-time and very long hours.
Does the father support the children going back to mother?
He does. And I think my understanding was he was asked about that during his evidence and confirmed that that was his position. and with the supportive family network around, they can build a system of monitoring and support for these children if it were considered appropriate that they should be rehabilitated to the mother's care in due course.
These quite young parents. I haven't got a picture.
They're 21 and 24. 26 and 24.
Okay.
Yeah.
Not very young, but not.
I would say very young.
Well.
So yes, they are young parents.
First time parents too.
Yes, yes. But that approach, my lords, would allow this case to move forward in a much swifter manner than if the appeal were to be allowed and there was to be a retrial, which in reality would be probably another 6 months at best, maybe longer. So, my lords, those are the points that I would make on the opposite side of the fence. Can I assist you with anything beyond that?
That's been very helpful. May I check if there are any other questions? Thank you very much. Yes, Mr. Barnes.
My Lord, if it please, I'm very grateful, and I should say that I think my Lord Justice Baker probably permitted the attendance of the Guardian remotely. She had other professional commitments. She is watching over the live link, and I'll be able to update probably over lunchtime. I don't know whether I'll necessarily have concluded by that point, but I'll try to assist in a focused way. My Lords. Obviously, the manner in which the appeal comes before the court is I think has been remarked upon, a slightly curious position in that fundamentally the local authority who analysed matters as leading to a pool finding in relation to the bite injuries pursues an appeal. In the ordinary course, there is at least one party who has an interest in seeking to uphold a judgment, if for no other reason than the findings represent a more positive outcome than they might otherwise anticipate. And of course, in this instance, there was, in certain respects, a preponderant degree of evidence that might have suggested some of the medical evidence pointed towards the father. And obviously, Miss Lee has, in the course of assisting the court with widening the horizons, but effectively the case that it might have anticipated that the father would have advanced in seeking to defend a case that led to a pool finding. I wanted to set out by way of a preliminary approach to the setting of the scene on the judge's task and what the advantages and what has driven the Guardian to support the appeal. To acknowledge firstly that the delay in the case has been extraordinary on arriving in the case following the grant of permission to appeal and drafting the skeleton argument. It was an obvious factor that sprung out, and I have sought to address in some detail in the course of my skeleton argument what appeared to me in consultation very helpfully with my solicitor, where those different strands fed into an overall picture which plainly is deeply unacceptable. On one view, the younger child was less than 6 months when these proceedings commenced and is now 2.5. So it isn't even a case where it is a majority of his life. It is by far the greatest percentage of his life.
So his primary attachment is with his grandmother.
I think grandfather, he's with them.
His primary attachment is with them, with his care, yes.
It is right to say that the worst impact of that might be said to be ameliorated by the fact that it has been consistently family placements, and that has facilitated a high degree of contact that has been ongoing throughout. That is obviously to make the best of a difficult situation. But
and does the Guardian, do you on behalf of the Guardian endorse what Miss Lee has told us about the generally supportive environment of the wider family on both sides?
Well, I'm less clear about the degree of support from the father's family, but certainly the initial placement, as I understand it, was with the maternal grandmother.
Yeah,
there was then a move to the maternal grandfather and I believe his partner. And I believe that the mother's proposal envisages her living with her own mother as well. So there are certainly a number of strands of positive family support that are available. And I apologise if I'm not as familiar with the paternal side. As it happens, obviously matters had somewhat refined down, because at the point that the proceedings have arrived at now, the father is not putting himself forward as a potential carer. The mother still is.
But there is a route then. One could see a route, depending on the outcome of any assessment, to the mother being reintroduced, going back to live with the grandfather and the children, and taking on a degree of responsibility for the children over a period of time, perhaps under a court order of some sort. That would be a route one might see.
I wouldn't necessarily wish to speak beyond the scope of what I have detailed knowledge of, but I have not understood that the relationship as between the mother and her father is as comfortable. I think he is obviously part of the current support picture, but I'm not sure her proposal envisaged living with him, for example, in the same way that it did to her mother.
With her mother, I see.
So the degree to which that assessment would necessarily fall in the way that my lord, I don't know, is certain.
Anyway.
It is conceivable, okay. and equally, of necessity, a failure to protect finding, and this was the analytical aspect that I was wanting to assist the court with. Is that obviously a pool finding, when that is arrived at, is an exception to the ordinary course of events where an allegation must be proven on the balance of probabilities, and it is to widen the net of the protection that can be afforded to children when that individual perpetrator can't be identified. But necessarily, it involves a greater degree of uncertainty than a specific finding against an individual. And no doubt that is a matter that is factored in when considering what the nature of the assessment is, but also the context, for example, of a parent maintaining a denial after a pool finding, because conceptually the court must acknowledge that one possibility is that a party who hasn't caused injury might be in a pool at the conclusion of that forensic process. And I think from the Guardian's perspective on analysing her position to support this appeal, it comes from this. The structure of the law to be applied now is clear. There was previously a self-direction that was very commonly given that judges shouldn't strain to identify an individual perpetrator. And that had led possibly to a tendency towards not necessarily fulfilling the focus on seeking to identify an individual, if that was possible, on the balance of probabilities. There are clear advantages in terms of the management of risk that arise from the capacity to identify a sole perpetrator, and that no doubt has informed why this court and the lead justice of Lady Justice King indicated that that aspect of a self-direction should no longer be given, and that the court's task is a clear one, that it should seek on the evidence that is available to consider firstly whether it can identify a perpetrator on the balance of probabilities, and in default of that considers whether there is a real possibility and who is on who falls within that pool. And that goes, and without seeking to be unduly po-faced about matters, there is a linguistic element of it in that the Court of Appeal and the decision of Lord Justice Peter Jackson in Re B encouraged practitioners to distinguish between the list identified of those who might have caused an injury, to then seek, if at all possible, to identify who the perpetrator is to the requisite standard of proof, and in default of that, one then enters the territory of a pool finding. And that is partly to encourage an approach that doesn't see it as the task of a parent to take themselves out of a pool, i.e. justifying why I shouldn't be considered one of a pool, when the forensic task goes the other way. That the burden of proof falls on the local authority, that it seeks to prove its case, if it can, on the balance of probabilities to identify a perpetrator, and it's in default of being able to do that one arrives at a pool. So I think just given some of the terminology about excluding or bringing oneself out of a pool, that's an important aspect. There is within the judgment a slight infelicitude.
Rapacity, isn't there, as to how she didn't quite do it in that way.
No, I think at one point she refers to the pool of potential perpetrators, I think meaning what we've been encouraged refer to as the list. But that is a minor semantic issue. But what the Guardian does consider is that for the children more than anyone else, there is an importance in having coherent and well-founded findings to take forward to consider how risk might be managed at the welfare stage. That if that forensic process is undertaken properly, it gives proper consideration to whether a sole perpetrator finding can be made, with the advantages that flow in terms of the precision of risk analysis that affords. And so that is where, on considering this appeal and the way in which I have framed matters in the skeleton argument that I have before the court, is to associate the Guardian in particular with ground B, which is a failure of analysis sufficient to vitiate the court's the findings of the learned judge, and also to factor in, under I think it is ground D, and then ground D, the failure to properly analyse the injuries to the ear. Now again, I started with the issue of delay because underlying the Guardian's approach here is an acknowledgement that the delay to date has been exceptional and something that is not of assistance to the children. It is conceivable, as the court has explored, for a pool finding to be the outcome and for that to be the basis for a future assessment of risk, were it not for her concerns as to the sufficiency and adequacy of the reasoning that underpins this particular decision. The Guardian is obviously mindful of delay, and so it is not a decision that she takes lightly and comes down to fundamental concerns about the adequacy of that reasoning that has been applied.
In that context, can I just ask you this? In the judgment, at paragraph 83, which is page 55 of the appeal bundle, the judge sought to summarise the Guardian's position before her.
Yes.
Was that an accurate summary of the Guardian's position? Did she record that correctly?
I think not quite.
Right.
On that, the court has the assistance of the document that was prepared by trial counsel on behalf of the children, which is within the bundle at page 65, if my lords are working from the hard copy bundle.
How many?
Page 65, I think it's electronic page 68. So this is the initial response document after the filing of the appeal.
Oh yes.
Yeah.
And I believe that does note that the manner in which the Guardian had put the case was slightly different. This is at paragraph 2. My Lord Justice Baker will be particularly familiar with the fact that there is ordinarily an approach where the Guardian, where the representatives of the children seek to assist the court in analysing the evidence, but not necessarily taking an active position on outcome.
Right.
I should say it's not precluded for a representative of a child to take an outcome. They are a full participant. There is judgments that consider that. But in this instance, as is stated there, the observations that were made on behalf of the Guardian were that there was a course for the court that would permit the court to identify the father as the perpetrator of the injuries. That dependent on the findings, it might be an alternate course that it wasn't possible to identify a perpetrator. So the issue that's taken is that the Guardian didn't go on to state or intimate the inference being that the court cannot safely conclude it's mum.
In fairness to the recorder, I think that's just the inference that she's drawing.
And it is the, in a sense, the other side of the coin.
Quite.
In saying that preponderant evidence might point towards the
Quite.
father. So
Quite. But
I think
say for that last, forgive me for interrupting, but say for that last clause, There's paragraph 83, lines 1, 2, 3, and the first half of line 4 accurately record what the Guardian was saying to the recorder.
I think to a significant degree it does. I noted this because the trial counsel, who obviously made the submissions, and I didn't, and the court has already noted we don't have a transcript of the submissions made, had specifically noted this point.
Right.
But I don't seek to rely on that as suggestive that that's the basis on which this court should set aside this decision. But as my lord had raised it, I thought that assisted as far as it can.
It is helpful. That is helpful. But what strikes me as being of some interest is that the Guardian's position before the recorder was, as recorded, that probably my conclusion should be that the perpetrator is Dad, but it would be open to me to say that it is an uncertain perpetrator, and in fact it was the second of those that she landed upon in due course.
Yes. I know that the court has been keen to explore the manner in which it might analyse this judgment in a way that doesn't lead to an appeal succeeding. No, not least because that hasn't been explored as fully. But I acknowledge in my skeleton argument that a pool finding was, on the appearance of the evidence, a conceivable outcome.
Yes.
It is whether there is a proper reasoning process to arrive at that outcome that is sufficient to satisfy this court that decision can be upheld. But given that the local authority was advocating that outcome as the end point of its analysis, it certainly wasn't precluded. So in analysing, if it assists, and it may be a summary of a number of the points that the court has raised, that the manner in which the parties collectively have to persuade this court to set aside this judgment seems to me to face the following 5 headwind points. That is obviously an experienced judge. It is a recorder, but as I understand it, the learner recorder sits full-time as a district judge, is relatively experienced, and is undertaking a fact-finding hearing where she, of course, has all the advantages of hearing the evidence and assessing not only that evidence, but the dynamics within the courtroom as well. And obviously that leads this court to apply a high standard of scrutiny to interfering with that decision. That bears on what I don't think I'd necessarily anticipated was an attack on one of the apparent factual findings that the judge was making in relation to the mother's attempt to assist, but I'll return to that in due course. The second, of course, is that this court does not have the benefit of any transcripts. It may be that had there been a greater appreciation of the degree of the court's anxieties, that some of the transcripts.
Well, I'm sorry. Maybe I should have anticipated that, but we don't have them.
No, but it is obviously a disadvantage that this court doesn't have the totality of the evidence, doesn't have transcripts of any of the experts or parents, albeit the judgment deals fairly fully with the evidence helpfully. But in any event, transcripts don't necessarily encapsulate all that goes on at first instance, and that is an advantage that's obviously acknowledged. Thirdly, and I highlight it within my document at paragraphs 9 and 10, there is no and was no disagreement at first instance as to the legal framework that had to be applied, and the judge plainly gave herself an entirely adequate self-direction on the law. Insofar as there wasn't extensive quotation from, say, the decision of this court in Re LW in relation to failure to protect findings not being a bolt-on, as I highlighted in assisting, it is a case that was referred to and that the judge at least name checks, and so can be taken to have considered it. Equally, in relation to the central finding of the bites, there is much that isn't necessarily taken issue with as to the forensic outcome that the judge arrives at. None of the parties take issue with the exclusion of the older child as a potential cause of the bite marks. There's also no fundamental issue taken by anyone that the judge was entitled to reach the conclusion that the marks or bruises, as she describes them, ultimately there was a justifiable conclusion that they were caused by the mechanism pleaded by the local authority, namely bites. And of course, this was a case where it isn't an uncommon forensic process in applying the language of uncertain perpetrator cases. There was a list, and it was a list of two once the older child had been set aside, and so it is an identification between the mother and the father. And then the fifth point I've made, I would raise, which obviously has been explored, is that a pool finding was not just a possible outcome, but one that the local authority was actively contending for. And in responding to that, I would advance, as I say, two principal focuses arising from the local authority's case. I'm not sure I would associate the Guardian with the formalistic approach of saying that a judge must mechanically address a schedule of findings as necessarily the only route by which to approach matters. Indeed, it's tolerably clear, and I'll come to the analysis of this because the court was indicating whether there may be different readings on some of the paragraphs, but there does appear tolerably clear findings that they were bites, that they were inflicted non-accidentally, for example. And indeed, certainly in private law fact-finding cases that the family court is dealing with, where there is a fact-finding hearing and a judgment given, the procedural rules mandate that the parties then agree the schedule of the findings made arising from the judgment. I don't doubt that that is practice that would ordinarily apply following a judgment in public law matters. And so even if the judge hasn't addressed matters by reference to the schedule, that would be capable of being addressed by the parties through the preparation of that schedule.
And it might be endorsed on an order too. Might be endorsed on the...
Indeed, and of course the check on that is that the parties take what they can from the judgment, but that it is ultimately approved by the judge to ensure that the summary conforms with the judgment.
And in doing that, they're not, neither the court nor the parties are bound by what the local authority put in its original threshold document. In fact, it's gleaned from the judgment. Sometimes it follows the threshold.
It does.
And sometimes it doesn't.
Given that I have seen many a disagreement about what exactly can or should properly be taken from a judgment in that way, it is obviously an area that can sometimes lead to disputes about what is a finding, what needs to form part of that schedule.
And is the judge is sometimes asked to rule on what goes in the order as a record of the findings? Yes, they are.
And of course, my lord is right. That schedule, in a private law context, ordinarily forms part of the order that flows from the fact-finding hearing.
Yeah,
that would be something.
And it does. You say you emphasise in private, but it does happen in public law.
Oh, absolutely. I think it's just that the procedural rules mandate it.
Do they?
To form part of the order in the private law programme. It may be if I check over the lunch and adjournment, it may be that it is mandated and therefore is something that should have been addressed here. But I'm not sure that it is quite as...
Anyway, it is not mandated. It's certainly acceptable and common practice.
Yes, and of course, on occasions, it's clear that a judge is simply finding a threshold as part of establishing a jurisdiction. But where there is a need to assess post-fact finding, as here, it's obviously of assistance to have that process undertaken. I should say, as a minor point of detail, the indication was given that this was listed as a fact-finding hearing. As I understand it, the intention had originally been for a composite final hearing. And as it happened, the Guardian had filed a final analysis which had pointed to deficiencies in the local authority's evidence that meant that the parties, and I think the recorder, I think the decision may have been taken by the circuit judge who dealt with a pre-trial review, that the matter would actually proceed as a fact-finding hearing alone. And that feeds in to the point of disposal, where one conceivable outcome may be for a composite hearing if there is a need for further consideration of the factual framework, as opposed to bifurcating the process in the way that happened here as a result of circumstances, as opposed to it necessarily being something that was deemed to to be forensically required in the circumstances of the case. I have also, in the course of the skeleton argument that I filed on behalf of the Guardian, and noting my Lord's observations earlier, it may be out of step with where the court is considering matters. But in my submission, the principal failures of analysis rest in relation to the conclusions as to the pool finding in relation to parents and how that was arrived at, and the failure to adequately address the issue, the injury to the ear. It seemed, on the analysis that I had brought, that the lack of clarity or proper consideration to the failure to protect finding was a potentially less serious overall failing, and whilst it went to an overall submission that I advanced that the judgment was deficient in its reasoning globally, it wouldn't necessarily sustain the appeal on its own. But of course, it may be that there are different ways that this court might approach it if it does have some concern about how that was addressed. But at the moment, it appears to essentially come to certain observations and a non-finding. The difficulty being, and I suspect the argument being, that if the court has been tasked with considering that at a fact-finding hearing and has made no finding, does that lead on a binary application to that not being something that is capable of being factored in previously? If there have been findings contended for that have not been made, can that be resuscitated through a separate later process of assessment when it isn't grounded on a finding that the court has made? I think that's the complexity of leaving the matter open, as my Lords had considered. So, my Lord, I wanted then to focus, though it may be if I'm addressing the two central issues, that I may be better after lunch, but I'm not sure what's convenient to the.
How much longer do you think you'll need?
I anticipate probably 20 minutes addressing the adequacy of reasoning in relation to the bites and the position in relation to the ear injuries.
Would it be convenient if we were to resume at 5 to 2?
I'm entirely in my Lord's hands.
If we break now, because there's one or two things that various parties I think are going to help us with, so it may be helpful to have a short adjournment to think about those things, and we will resume the hearing at 5 to 2.
Thank you.